Thank you very much, Gisella. Well, hello, everybody. My name is Gisella Alvarado. I'm a senior associate at Sagardoy Abogados, Spain. And now I'm really happy to introduce my colleagues who will be analyzing this trending topic with us. We have here Ms. Anne Cattoir, senior associate at Claes and Engels, Belgium.
Hi, good afternoon, everybody.
We have Jan Hauer, principal counsel at Klimt, Germany.
Hello, good afternoon from rainy Düsseldorf in Germany.
And we have Guillaume Bordier, partner at Capstan Advocates, France.
Yes, hello everyone. Pleased to be with you today.
Okay, so let's start by talking about the implementation status of the Whistleblowing Directive. In summary, you should know that 25 of the 27 member states have already transposed the EU Whistleblowing Directive into national law. Next, 17th of December 2023, is the deadline for companies that employ less than 250 and more than 50 employees to implement whistleblowing reporting systems. Although the directive has not been transposed in the same way in all EU countries, and there are some particularities that we will address in this session, the aim of the new regulation is the same in all countries. That is, to protect natural persons who report acts or omissions that may constitute breaches of union law in a specific areas listed by the directive, and consequently prevent whistleblowers from suffering any form of retaliation for having reported such acts or omissions. In this webinar, we will cover 7 topics, focusing on what employers need to know to implement whistleblowing reporting systems, and of course, what are the challenges in these implementations. So, let's go. The first topic that we will discuss is the material scope of the directive. As you know, the directive only protects people who report breaches of union law in specific areas. For example, public procurement, public law, consumer protection, among others. However, companies want to know whether local law extends protection to reporting breaches of national law or even company policy. And does the protection extend to reporting cases of harassment, violence, bullying? And if so, would whistleblowing protection apply to such a wider national scope? So let's start. And Guillaume, any relevant comments from France?
Yes, thank you, Gisella. Yes, a very important comment regarding France, and I think that it could be the case in many countries, so it would be very important for all companies to check what the national law provides for. So by way of introduction, it is important to note that since 2016, French law has required all companies with more than 50 employees to establish a whistleblowing procedure, and this with a very broad scope of application. And another thing which is important is that this obligation to have a whistleblowing procedure is part of a more general framework to fight corruption. And this was the aim of the law of 2016 to fight corruption in a very broad sense. So this law of 2016 also provide additional obligations for companies and French groups with more than 500 employees, which includes the obligation for these companies to have a code of conduct and an internal whistleblowing system designed to collect reports from employees concerning any violations of the company's code of conduct. So the scope is even broader for large companies. So the law of 2016 has been amended after the directive because it was not fully compliant with the EU directive. So it was amended to reflect the additional obligation provided by the EU directive, but of course it has not cancelled all the obligations which were already going beyond what the EU directives provided. In addition, a law of 2017 on the duty of care of parent companies has provided that large groups with more than 5,000 employees must have a vigilance plan to protect violations of human rights and fundamental freedoms, health and safety, and environment. And with, again, an obligation for these very large companies to have a specific procedure to report any violations in these areas. So you can see that depending on the size of the company, there may be several obligations for the management. So now for the smallest companies, so any companies with more than 50 employees, which corresponds to the scope of the directive, the material scope of French law is very broad and much broader than the material scope provided by the EU directive, because anyone can report any breach of French law, so not only European laws, but any breach of French law, notably, of course, violations which constitute a criminal offense. Of course, any violations of international treaties, including European laws, and more generally, any harm or threat to the general interest. So you can see that the scope is very broad. And of course, it includes any situation of harassment, violence, bullying on the workplace. As mentioned before, for the largest companies, this could also include any violation of the company code of conduct. And what is important also to know is the French Data Protection Authority considers that any alert which would fall outside of the scope of the whistleblowing policy, even in this case, the company must guarantee the same level of confidentiality and the same level of protection for the whistleblowers, even if the report falls outside of the scope of the procedure. So maybe we can turn to Germany now.
Sure, thanks, Guillaume. And in Germany, it's a bit different. In Germany, we've not had a national whistleblowing law so far. In Germany, there was interestingly going on a quite controversial discussion under our former government, under the Merkel government, about the scope and about the question in how far the national law shall extend the scope of the EU directive. And at the end of the day, it was the Scholz government who found a compromise. And according to this compromise, now in our national law, the scope includes not only breaches of EU law. The scope was extended, but not as broad, I think, as in France, Guillaume. It was extended only to criminal offenses under German law, of course, and to administrative offenses under German law, insofar as these administrative offenses violate regulations that serve to protect life, limb, or health, or to protect the rights of employees or their representative bodies. Maybe to give you two examples where this extension plays a role. First example is breaches of the German Minimum Wage Act. And the second example is breaches of works constitutional rights of workers' councils. I think this will be a quite relevant field. And we'll see how many reports we'll get on this in this field. Needless to say, I think, is that in the individual case, it can be quite challenging to determine whether a case falls under the scope or not. Not only challenging for the whistleblower, but also challenging for the person who receives the report. And I think this will be one of the fields where legal advice will be required. But we'll see how often that will happen. And all in all, it's a broad scope, but not as broad as in France, I would say. So let's move on then to the second topic, Gisella.
Thank you very much, John. Okay, so now we are going to talk about centralized reporting system. As you know, the directive states that legal entities in the private sector employing between 50 and 249 employees may share resources to receive reports and carry out the entire investigation. In Spain, which is my jurisdiction, centralized reporting systems at group level, at group level under Spanish law, must meet specific circumstances or requirements. First of all, the group must be defined as a group of companies as under Spanish law, and the parent company must approve a group policy covering and guaranteeing certain matters listed by law. But how does it work in Belgium, Germany, and France? Is it allowed to centralize reporting systems at group level? And if so, what are the challenges of implementation in these countries? And legal thoughts from Belgium?
Thank you, Gisella. This is a very interesting question. It's a hot topic for many international clients. For Belgium, unfortunately, the answer is not crystal clear. For smaller companies, the law in Belgium confirms what the EU directive has indicated, namely organizations with 50 to 250 employees, they can share resources to organize a joint channel. So for smaller organizations, it's clear, group channels are allowed. On the other hand, for organizations with more than 250 employees in Belgium, the group channels are not expressly allowed, such as, for example, in Spain on certain conditions, but nor are they expressly prohibited. So some are of the opinion that as the possibility to share resources is only mentioned for the smaller companies, that is not allowed for the larger companies. This is also in line with a very strict point of view of the EU Commission. So the EU Commission issued 2 non-binding statements in June 2021. The EU Commission is of the opinion that it's not enough to have only a reporting channel in a centralized manner at group level. In other words, all companies belonging to the group should have their own reporting channel. And this is the strict opinion of the European Commission. On the other hand, we see that in a number of countries there are, such as Spain, and group channels can be allowed. So for Belgium, a company does have the possibility to outsource the channel and the management of the channel. So why wouldn't it be possible to outsource the local internal channel to the group level? So at Kleijs & Engels in Belgium, we have adopted a pragmatic approach until now, as the legislation is not very clear. And so we believe it is defendable to work with a channel at group level, provided that there is a policy at local level, that there's information consultation at local level, that the language requirements are met at local level, and so on and so forth. So it's yet unclear whether this position will stand, but for the time being, we tend to advise that indeed group channels are possible for international organizations. And maybe to add a final remark, to be on the safe side, what we see in practice is that companies, they indeed have their reporting system at group level. And in addition, they can implement a very simple, a very straightforward reporting system at local level. For example, an email address, whistleblower@company.com, to have a reporting system at local level, and in addition have a broader online platform at group level. So this is it for Belgium. I'm interested to hear if this is also a difficult topic in Germany.
Yeah, of course, also in Germany, it's a hot topic, as you said, Hanne. And the situation in Germany actually is more or less comparable to the situation in Belgium. We also have this uncertainty, which you mentioned, not for smaller companies, where the directive was implemented one-to-one into national law, so they can share resources if they do not have more than 249 employees. But for companies which have 250 employees and more, it is challenging. Why is it challenging? Because, of course, also we do have these 2 EU Commission statements of 2021, and the German legislator picked this topic up, and the German legislator clearly wanted to allow centralized systems, but they did not expressly mention it in the law itself. In the German law, it only states that third parties outside the legal entity can be engaged. And it's then only in the memorandum on the grounds of the law where the German legislator explicitly referred to group constellations, where it states that third parties in the meaning of the law can also be a group company, a parent or a sister company, as long as, so it says, the assigning entity remains responsible for the prosecution of the breaches of the law. So the German legislator wanted to allow centralized systems, but there must remain a certain degree of control with the entity. This is, I think, something which must be reflected in a service level agreement, and not that easy to reflect this, where legal advice, I think, will be required. From my experience in advising companies, it's more or less as you mentioned it for Belgium, Hanne, that despite this uncertainty, many groups do decide to take the practical approach and do establish centralized reporting channels. And my personal opinion is that at the moment in Germany, it's very unrealistic that this approach could result in a fine, because the approach is clearly in line with what the German legislator wanted. And of course, so far, no German court has had the possibility to rule that a different interpretation of the German law would be required, maybe more in line with the EU Commission. Maybe this will happen one day, but has not happened so far. Maybe some things regarding the international level. If you want to establish a centralized system on the international level, of course, this then must be allowed in every country that participates in the centralized system. I know that not in every EU country this is allowed. And of course, companies must take into account the national whistleblower protection laws of all those countries who participate, because of course a whistleblower then could come from one of these countries, and this can be quite challenging. The question which national law applies if you have a cross-border case, for example, if the whistleblower is in one country, maybe witnesses or other persons involved are in another country or other countries. I think also there it can be challenging in practice, which provisions you must comply with. That's for Germany. I'm wondering whether the situation is comparable in France, Guillaume?
Yeah, situation, thank you. The situation is very similar in France, so I think we could go quite quickly on this topic. In France, like has provided in the EU directive, legal entities with less than 250 employees can implement a common procedure for collecting and processing the reports, but it is clear that the entire process cannot be delegated. And there is a discrepancy in France between the law and the application decree, because the law provides for a very general principle that there can be a common procedure for collecting and processing the reports, which is quite broad, whereas the decree mentions that only the receipt of the report and the assessment of the accuracy of the allegation can be processed through a common procedure. So therefore, we consider in practice that it's important that the local entity is also has an obligation to act individually, of course, to provide feedback on the actions that have been taken, to provide feedback to the whistleblower of the actions that have been taken, to of course implement the actions to remedy the matter, and also the local entity is bound by the confidentiality obligation. But in practice, we apply the same pragmatic approach than in Germany or in Belgium. We consider that, and a lot of international companies have a single reporting procedures. And regarding the investigation, we consider that the investigation can be made at group level or at local level, depending on the circumstances. Of course, sometimes it's not possible to investigate locally, something which involves, for instance, a VP, where it is not possible for the HR manager or the HR director of the local entity to investigate the matter. So in this case, we consider that it's appropriate that the reporting is investigated at global level.
Okay, thank you very much, Guillaume. And now let's move to the third topic and talk about whistleblower officers. We have seen that companies have several concerns about the possibility of having all reports handled by their compliance officers at group level. In particular, some national laws do not allow this and require a local whistleblowing officer to receive and follow up reports. How does it work in the countries we analyze? Are companies required to have a local whistleblowing officer? Jan, what is the German legal position?
Thanks. No, companies are not required to have a local whistleblowing officer. They can, of course, have centralized systems, as I just mentioned when we talked about topic number 2. And that would usually then mean, if you have a centralized system, that you also have a centralized officer or a centralized unit that deals with the reports. And it's also up to the company to decide who deals with the report, which unit. That can be somebody from the compliance team, that can be somebody from HR, from legal. There are no requirements in the national law. Nevertheless, it can make sense to have a responsible person on the local level in each group company, I think. One of the reasons is that according to the German law, which insofar only implements the directive, companies must organize a personal meeting upon the whistleblower's request, and it might be helpful if companies have identified in terms of a standard procedure who will be this person on the local level, who in that case, if requested, could get into touch with the whistleblower. And the second reason is that maybe for internal investigations, of course, local resources might be required. One example is employee interviews, which maybe can only be organized on the local level because they are in touch with the employees. And also for this constellation, it could make sense to have identified the person or the unit on the local level who deals with it beforehand. How's it in Belgium, Hanne?
Well, in Belgium, it's very comparable. It's not strictly obliged that there is a local internal whistleblowing officer who is appointed as the whistleblowing officer. It indeed depends on the structure of the company. And so a company has the obligation to appoint someone. However, the company, as you said, also is rather free to decide who is up for the task. Of course, taking into account the guarantee of independence and the guarantee of absence of conflict of interests. That has to be taken into account. So that can be a local officer, such as compliance chief, HR manager, legal officer. However, as I explained, as it is allowed to outsource the internal channel and does the management also of the internal channel, the whistleblower officer can also be a third party. It can be, for example, an external counsel. The legislator in Belgium has confirmed that. However, when it is an external party, a third party, for example, do note that, of course, the final decision on, for example, measurements to be taken will be the responsibility of the company. So the external whistleblowing officer will have to revert to the company in this context, and so the company can take a final decision. But to sum up, in Belgium, no strictly obligation to have a local whistleblowing officer. Gisella, how does it work in Spain?
Thank you very much, Anne. Well, in Spain, a whistleblowing officer must not only be appointed, but also this person must be communicated. The appointment of this person must be communicated to the Spanish authorities. In any case, this officer could be the same one for the whole group or even for certain companies of the group. Of course, in line with the fact that centralized reporting systems at group level are also allowed in Spain, as mentioned before. Well, as you see, interesting answers are being discussed. However, we consider highly advisable for you to know the most important aspects to successfully implement a policy regulating whistleblowing reporting systems. This will be our fourth topic. And Guillaume, so what would be important from a French point of view?
Yes, so from a French point of view, I can start with the language. Maybe it's not the most interesting topic and the most significant one, but of course, these kind of policies must be drafted in the local language. So in France, in order for all the French employees to be fully aware of the content of the policy. but maybe it's something which is obvious. One thing which is important is that, unlike in other countries, the ministerial decree which has been passed by the French government provides for a very comprehensive list of requirements regarding the content of the policy. So it's very important to take a look at the French requirements to have a compliant whistleblowing policy which contains all the information and all the procedural steps which are required under French law. And from my experience, this has led some international companies to have local annexes, so global policies, but with local annexes, in order for all the local annexes to, or for the policy to comply with local requirements. In France, for instance, the whistleblowing policy must describe the channel for the receipt of the report, but the decree goes into many specific details on how the report can be made orally, in writing, via video conference, in a physical meeting, and the deadlines which apply to that. Of course, there is the obligation to inform the person who has made the report within 7 days. That's a common requirement. The way the company will assess if the report meets the conditions, and the way this will be reported to the person who made the report, must also be described in the policy. One thing which is important, and we already discussed that, is the persons who will be responsible for collecting and processing the reports. French law says that this person must have the skills, the authority, and the resources to be able to carry out their duty in an independent manner, and they must receive specific training. So this of course, the policy can be a little bit flexible and say that depending, of course, the report can go to one designated person. We have already addressed this. But then who will conduct the investigation? The policy can be flexible, but the policy must contain guarantees in terms of impartiality, the absence of any conflict of interest. You must also include provisions regarding one very important matter, which is the integrity and the confidentiality of all the information that will be collected and processed during the investigation process. And the French data protection authorities, I don't know if it's the case in other countries, but the French data protection authority has also issued very clear guidelines on how to handle this kind of process. In addition to these obligations and the information that must contain in the policy, it is also important to implement the policy according to the French procedures. The Works Council must be consulted, so the Social and Economic Committee, which is the name of our Works Council, must be consulted if there is such a committee, but it's mandatory for all companies with 50 employees. So most of the companies should have a Works Council, and it should be consulted. And it's also important to make the policy public, so that any person who can make a report, so in France, not only employees and former employees, but also candidates, subcontractors, and the employees of the subcontractors must be properly informed about the existence of the policy. So usually it is published on the company website. It can also be appended to the contract that the company signs with service providers and subcontractors, so that the subcontractor is aware of the existence of the policy according to French requirements. So that's basically it for France. Now I think it's Germany probably about this topic, or maybe another country.
I'm fine with going on with Germany. First of all, interestingly, in Germany we do not have any obligation to implement the policy on whistleblowing. So I think this is a difference. Of course, many companies do implement policies, and in this case, I think it's very important that they describe very thoroughly the use of the reporting channels, including the scope, which case falls under the scope of the German Whistleblower Protection Act, which doesn't. Also to explain the protection measures for whistleblowers so that they feel encouraged to do whistleblowing. But even more important, especially in Germany, I think, is the question how companies achieve that the policy is well known and that employees accept a whistleblowing culture in a positive meaning. Because the tool of a policy is not that popular, I would say, as it is in other countries. And quite often companies have their policies, but nobody gets aware of the contents of the policy. So I think it is important to take this opportunity for the management to show that whistleblowing is something that can help the companies, and that is something that employees feel encouraged to. Why can it help companies? Of course, it can protect companies from administrative fines, but it can also mitigate image risks. For example, if certain misconduct becomes public before it was thoroughly investigated internally in the company. And for that reason, I think the communicational aspect about the contents of the policy plays an important role. And this should not only be one communication, one email, or one link. Here you can find the policy on the intranet. Rather, there should be trainings, I think, for employees, especially also for executive staff, including regular fresh-ups, where you also discuss maybe fictional cases which fall under the scope and how the company would like to deal with it. So to sum up, in Germany, many companies do not have a whistleblowing culture as it may be the case in other countries. And I think using a policy, doing a good communication about the contents of the policy can help to implement this whistleblowing culture. How is it in Belgium, Hanne?
Well, for Belgium, in terms of implementation of a whistleblowing policy, it's not obliged, but in practice, we do see the implementation of a policy in each company. And in practice, we see the following steps. We see 6 steps to be taken by the companies. So first step is rather obvious. The company has to draft an elaborate policy, and it's a little bit comparable to France, actually. It has to be very elaborate, the policy. So the material scope should be listed, who can file the reports, how does the channel work, how does it function, how is the protection granted, etc., and so on and so forth. So important issues here is have an elaborate policy on the one hand side with a lot of information, and second of all, also as in France, respect of the strict language legislation here in Belgium. So for example, company vested here in Flanders, it has to be in Dutch, the policy. So that's step 1. Step 2 is in parallel with step 1, and that's to conduct a data protection impact assessment to challenge the system that will be implemented. Step number 3 is inform and consult with the Works Council. If there's no Works Council, then it's the Health and Safety Committee or the union delegation. Important is that there's no need for an approval of the Works Council, but it's information and consultation. There is no formal approval. Step number 4 is informing the employees. That's also, of course, mentioned in the EU directive. It's very important that all employees are informed by means of a policy then in practice in a very clear, a very easily accessible manner. So that is a reason for which a policy is in Belgium the option to be chosen. Step number 5 then is to include the reporting channel in the data processing register and also in the privacy notification. But that's, of course, a GDPR aspect, but that's also important here. And then the final step, sixth step, and that's what we see for a lot of companies who already have an existing code of conduct, that if applicable, that those companies, they have to adapt their current existing code of conduct or code of ethics to be compliant also with the new legislation on the whistleblowers in Belgium. So Gisella, I think we can jump to the next question or the next topic.
Thank you very much, Anne. Yeah, now let's move to topic number 5. Okay, so according to the directive, consultation obligations with employees' representatives must take place before implementing whistleblowing policies. However, what happens in countries like Germany, where co-determination rights also exist? So, Jan, feedback from German?
Yeah, when we talk about the involvement of works councils and co-determination, we always come to Germany because indeed Germany is a bit special in this regard. How is it with whistleblowing policies and whistleblowing systems? The implementation of a policy and of a digital platform, whistleblowing platform, is subject to the works council's co-determination. So the company will not be in the position to implement the policy without the works council's consent. Why? Actually, for 2 reasons. Reason number 1 is that any policy will have the request to make a report if you observe any misconduct, and such a request is subject to co-determination because it affects the so-called social interaction between the employees, because an employee knows that if I do something wrong, then my colleague might report this. The second reason why it's subject to co-determination is that a digital reporting channel or reporting platform will create a so-called monitoring pressure, which is a typical case of co-determination, because there will be employee data on their conduct stored and processed in the system. And that's then when you need to reach approval from the Works Council. I think it's very important to be aware of this need to get the Works Council involved, especially for project timelines, because especially when you have international centralized systems, you cannot say, hey, Germany, here's the policy, please implement it, and from tomorrow on, this shall go live, because the involvement of the Works Council can take some time, up to a couple of months, which should be taken into account. You must then choose the right approach towards the Works Council. This, of course, depends a little bit on the individual situation, how the relationship is with the Works Council. But from my experience, it's very important that the Works Council gets involved rather earlier than later, that the company provides information, for example, on the provider that you want to collaborate with. When you talk about the tool, provides information on the decision where you want to locate the internal reporting channel. And then that the company also reflects the Works Council's concerns that they might have. Also, irrespective in the first step of the question whether these concerns are subject to co-determination or not, because even if they're not, the company might take them into account and implement the Works Council's concerns, which would then help to get their approval. Nevertheless, you might reach the point where you do not get approval from the Works Council. And if a company sees that this is the case, then it must also make it clear to the Works Council where you see the boundaries of co-determination. To give an example, the question of where within a company you want to locate the reporting channel, be it HR, be it legal, be it compliance team, is something of the free organizational decision of the company. So this, for example, is not subject to co-determination. And if you see that you don't reach an agreement in the negotiations with the Works Council, then under German law, you have the option to call the so-called Conciliation Arbitration Board, in German Einigungsstelle, where you have a chairman who can help then to bring the discussion to an end. And then with the help of this board, at the end of the day, the Works Council can also not block the implementation of a policy, nor block the implementation of a digital whistleblowing system. That's it for Germany. Challenging enough here and there, but something that must be taken into account. So shall we move, Gisella?
Thanks, Jan. Really interesting information. All these co-determination rights were really, really interesting. So now let's move to topic number 6, and which refers to whistleblower protection. In practice, in all countries where the directive has already been transposed, protection against retaliation applies to whistleblowers, facilitators, individuals associated with whistleblowers, and even legal entities related to the whistleblower. Hanne, in Belgium, what protection these persons have and how it is warranted?
Yeah, so indeed, any form of retaliation is forbidden. This is mentioned in the EU directive, and this is very broad. So it concerns actual retaliation, but also threatened retaliation or attempted retaliation. And the EU directive already foresees a long list of prohibited retaliation, such as dismissal, demotion, not promoting, disciplinary action, negative performance review, and so on and so forth. And as you say, Gisella, it's indeed the case that the directive states that all member states should take the necessary measures to prohibit any form of retaliation. And so for Belgium in particular, this protection is ensured via several protective measures. For example, a reporter can file a claim to the federal coordinator to stop the retaliation or to remedy the harm. That's one option. Second option is a claim can be filed before the labor court. So to seek corrective action against retaliation. Also, the burden of proof regime is favorable for the alleged victim of the retaliation. And also, the employee, for example, has the right to seek compensation up to 26 weeks of salary if he or she claims that he or she is the victim of retaliation. And so there's, to conclude, elaborate protection is foreseen here in Belgium, and I assume also in other countries.
Yeah, thanks, Hanne. Very similar also in Spain. Okay, so finally, we will talk about sanctions, which is our last topic. Why? Why our last topic? Because nothing lasts forever. So, legally speaking, okay, what you should know is that member states must implement effective, proportionate, and dissuasive penalties to those natural or legal persons that hinder or attempt to hinder reporting, retaliate against protected persons, breach the confidentiality obligations of the identity of reporting persons. But what kind of sanctions have been implemented in countries being analyzed? Can we talk about economic fines, remedies, compensation for damages, even imprisonment? So Guillaume, what is the French position?
Yeah, so in France, like in Belgium, whistleblowers are protected against any type of retaliation and cannot also be held criminally liable for the report they have made, even if the report found to be unjustified. And any act of retaliation is null and void. So it means that, for instance, if an employee is dismissed after a report, then his dismissal would be considered null and void, and he will be eligible to receive damages for null and void dismissal according to the loss suffered by the employee, but with a minimum of 6 months of salary. But this is the general principle when a dismissal is found to be null and void. Reinstatement in the company is also an option, but it's very, very rarely applied. On top of that, there are two main sanctions which have been provided by the new law. First is the fact that any person who would obstruct in any way whatsoever the transmission of a report made by a whistleblower is liable and can be sentenced to up to 1 year of prison and a fine of up to 15,000 euros. So you can see that 1 year of prison and 15,000 euros, you can see that it's quite unbalanced, but in many occasions, French law provides for imprisonment sanctions, but which are almost never applied in practice. So the fine is a fine of 15,000 euros. And on top of that, the law provides that abusive or dilatory actions against a whistleblower is punishable by a civil fine of up to 60,000 euros. And the employee or the person who reported can also be awarded damages as a result of the actions against them. So this civil fine of 60,000 euros plus potential amounts of damages. The breach of confidentiality is also a criminal offense which can be subject to a fine. Finally, something which is quite strange is that the fact for a company not to have implemented the whistleblowing policy, whereas it had the obligation to do that due to the fact that the company employed more than 50 employees, is not subject to any specific sanction. So companies could consider that because there is no sanction, there is no real enforcement of the obligation to have a policy in place. However, I think that in practice, an employee or someone who would have been allowed to make a report and was not able to do that because of the absence of policy could probably obtain damages and consider, if it's an employee, that the duty of care of the employer has not been complied with. So it's a potential award of damages which can be at stake. And what about in Belgium, Hanne?
Yeah, in Belgium, any breach of the whistleblowing legislation, so also not having a reporting channel, that can be punished with a sanction of the highest possible level in the social criminal code. So it's sanction level 4, that's the highest sanction. And this means either a criminal fine of 4,800 euros up to 48,000 euros per employee, or an imprisonment of 6 months to 3 years, but indeed in practice it's not very common, or an administrative fine of 2,400 euros to 24,000 euros per employee. So be careful, because these sanctions, they can be imposed not only on the employer, the amount times the employees employed, so that can be a high number, but also not only on the employer, but also on the employee or on any person who, for example, obstructs reporting. So for companies, it's important to indeed to be compliant with the whistleblowing legislation, as the sanctions can be substantial.
I think this is very interesting, if I may add something for Germany, because sanctions for non-implementation of a reporting channel are not that high. First of all, the German law came into force in July this year, but sanctions apply only as of 1st of December this year, so companies would still have some time. But more importantly, the maximum sanction would be 20,000 euros for the company, not per employee. And of course, this is one of the most. This is one of the questions which I most often receive. Which are the sanctions? And the fear to get such a fine is not the main driver at the moment for companies to implement their reporting channel. The main driver actually in Germany is that, and it might be the same in your countries, is that if you don't have your internal reporting channel, then employees could go to the external reporting channels, which are located at the German authorities. And of course, if you have a delicate case, maybe you as a company do not want this. You prefer to have this investigated internally, and that then is why you want to have your internal reporting channel to, let's say, remain control over the case.
Thanks, John. Thanks, Hanne. Thanks, Guillaume. Well, in the case of Spain, Spanish employers might be sanctioned with really interesting, relevant economic fines, which range from 100,000 to 1 million euros for breach of whistleblowing local regulation, depending on the seriousness of the infringement. As a result, it's a really key aspect to be considered. Well, I think that the 7 topics have already been covered. Thank you very much to the audience for your attention. And of course, happy to read your questions. We have here, okay, we have one question saying, are companies publishing a policy on their website and then a different version internally? I think here, John, it would be relevant if you can answer this question, considering that in German, publicize the whistleblowing policy is highly recommended based on what you just mentioned. So could you please answer this question?
Sure. I mean, from the legal perspective, you could do that because, as I said, you do not even have an obligation to have any policy at all. So you would be free in the decision to say, I have an internal whistleblowing policy and I have an external whistleblowing policy. However, I do doubt whether this makes sense because to me at the moment it seems a bit weird to have 2 different policies for internal use and for external use on the website, and for that reason I think the more relevant question for employers, companies, is to decide who shall have the possibility to make a report. You only have the obligation to open your whistleblowing channel to your employees, and it's up to you whether you want to open it also to external people. And if you do that, I think in that case, then it would be only consequent to have the same rules, and this means that to have the same policy also for external use, which you then would publish on your website.
Yeah, I can fully agree, Jan, because for Belgium, it is the law states that the reporting system should at least be applicable for the employee. So the reporting system can also be applicable for example, freelancers or other non-employees. But if you choose as a company to only allow for employees to report, then it's an internal policy. It's not on your website. It's more on the intranet, for example, or something internal within the company. If you choose to have the system also open, for example, for freelancers and others, then indeed you can have the policy. And we see that with a lot of clients, they have the policy also on the website. And then the content of the policy is more or less the same because it entails the material scope, the how can you report, how will feedback be given, etc., etc. So yes.
Thank you very much. Now we have 2 additional questions, which in a sort kind of way are connected. And I will highly appreciate if Guillaume could answer them. So I'm going to read those both questions. The first one is, hi everyone, if reporter, whistleblowing and subject are from different countries, which country law is in place? And then the other one, also connected, is in case of a company having only one legal entity in a country and employees in the said country and in 5 other EU countries, which laws would you recommend to refer to when implementing the whistleblowing system? Only the law of the country of the legal entity, or should we also make sure our system is consistent with applicable laws where there are employees? Just give me 1 second, because the answer was, the question was deleted. Yeah. Well,
yeah, I can answer the question.
Yes, thank you very much, Guillaume.
Don't worry. I think that if the reporter is based, the whistleblower is based in one country, he should apply, or he should refer to the policy which applies in the country where the person who is reporting is based, even if this person reports facts concerning, I don't know, his manager based in the US or based in another country. I think that the policy which has to be applied is the policy of the country where the person is located, the person who is making the report. Now, the second question is I think a little bit different because it's referred to the obligation for a company which has operations in several countries to implement policies. I think that in such a case, if we imagine a Belgian company with 5 employees in France, there would be no obligation for this entity to have a French procedure, because we would take into account only the number of employees employed in France. I don't know if you have the same interpretation, Anne or Jan or Gisella, but I think that it really depends on the headcount of the company in each country.
Yeah, I agree with you, Guillaume. Okay, so now we have here one question for Spain. What are the Works Council rights? Just information. Also, is it legally required to have a local officer? Okay, so first of all, we have to deal with consultation obligations with employees' representatives here in Spain. Okay, and also something that you have to know is that a whistleblower officer must be appointed and communicated to the Spanish authorities. It doesn't mean that this whistleblower officer must be a Spanish citizen. The whistleblower officer for Spain may be someone appointed among any employee from the whole group, or even for certain companies of the whole group. Here, another question. Hi, can several legal entities, each with more than 215 employees, share one single responsible designated person per country on an EU level? Example, one single designated person for all legal entities in France. From a Spanish point of view, that would be perfect. This would be the whistleblower officer. And as long as designation process is met and this designation is communicated to the relevant Spanish authorities, that would be fine. So what about France, Germany, and Belgium?
This is the way where France is not, so the French law is not very crystal clear. But we can consider that because French law says that legal entities with less than 250 employees can implement a common procedure for collecting and processing the reports, I would consider that if all the legal entities have more than 250 employees, they will all have, each of them will have to have their own designated person to receive the reports.
Thanks, Guillaume. We have here one additional question for Germany. Does the German law foresee a duty for companies to do trainings with employees?
Trainings with employees, yeah. The law actually only generally states that those who deal with the reports, that they must have adequate knowledge to be in the position to deal with the reports they receive in line with the law. But of course, it's pretty unclear what this means. From my point of view, and that's also what we advise, this means actually 2 things: that you must do a training with these employees dealing with the reports at the beginning when you have established the whistleblowing system. I think how long this training can be, it depends very much on the people, how much knowledge they already have they a legal background or not, but a couple of hours should be the minimum. And then what we also say is that you as a company must do ongoing trainings every 6 or 12 months with these employees, also taking into account the experience they have gained with dealing with reports in the meantime. What is not mentioned actually in the law is that, or how far a company must do trainings with the potential whistleblowers, so with the whole staff. This is therefore not required. However, I would recommend, as I said when we talked about policies, communication is very important, to also hold trainings for employees, especially how to do a report, to explain to them what happens next when they have made a report also to explain to them protection measures, etc., etc. Again, also for Germany to trigger this change of the whistleblowing culture a little bit and using the tone from the top.
Many thanks, John. Okay, well, thank you very much to all the audience. It has been really nice to share this webinar session with all of you. And now, Gisella, do you have anything else to add?